Yes, Mr. Ashworth.
My Lord, we won't deal with the no reflective loss point. Reflective loss point in light of the extent there is no loss caused by the company. So that takes us to ground 6, which is paragraphs 4 and 5 of the prayer should go in any event, which we discussed briefly before lunch and adjournment, and the judges erring in law by saying it may pronounce a claim for indemnification, paragraph 4, which simply doesn't work. It also doesn't work, my lords, because Article 14 of the Articles of Association, which are in the supplemental bundle, page 132, provides all officers of the companies with an indemnity out of the company's.
Sorry, where this is relates to which paragraph of the prayer?
Paragraph 4 of the petition, my lord. Paragraph 4 of the prayer petition.
Page.
So page 116, my lord.
Thank you.
116
116.
of the supplemental bundle.
No, 116 of the core bundle for the petition, my lord. And the article is at page 132 of the supplementary bundle.
Right.
No, I haven't got which page of the supplementary?
132, my lord.
132. Right.
Indemnity.
Indemnity. So Article 14 gives every officer of the company indemnity out of the company's assets. And therefore any claim by the company against the directors for breach of their duties would fail for security of action. In terms of this indemnities, there would be no valid claim against the director. So his lordship's characterisation of this as an indemnity, which was not something raised during the hearing, that simply wouldn't work.
Sorry. I'm sorry, I'm just not following this argument.
So paragraph 4 of the prayer, my lord.
Yes.
His Honour Judge Eyre said was effectively to be read as a claim for indemnification.
What, the company be indemnified?
The company be indemnified by
the directors for
their breaches.
For their right.
And then effectively he said essentially that Zedra could recover from the company sums which should have been payable by the directors for breach of their duties.
Breach of duties to the company.
To the company.
Right.
By way of some form of indemnity. And it's what his lordship said, so I probably should take it back to paragraph 64 of the judgment, which is at page 86 of the core bundle.
Well, the point is, if there's a finding of breach of duty, they can't indemnify him against that. They can indemnify against costs if he's found innocent.
Well,
is that right?
Article 14 gives an indemnity against costs, charges, losses, expenses and liabilities incurred by him as a relevant officer.
Yes. In the actual or purported execution of his duty, or in which he's acquitted, or the proceedings are otherwise disposed of without any finding or admission of any material breach of duty in connection.
Including that, my lord.
Oh, including that.
So it starts including in each, below subparagraph B, including in each.
Sorry. Yes, okay, yeah.
So this would just be wrong for security of action, so it wouldn't work.
I thought there was a provision in the Companies Act that said that a company couldn't indemnify an officer against breach of duty to the company by the officer. My recollection is quite a long-standing provision. Are you aware of any such provision?
Oh, my lord, not at the top of my head.
All right.
To say there isn't.
All right.
Somewhere
anyway,
else.
Subject to that, you say that this fails by virtue of 14.1.
For circularity.
Yeah, thank you.
And then ground 6.2 of ours, which is the paragraph 5 of the prayer we dealt with before the lunch adjournment. It is, we say the only way you can probably read this is breach of duty by the directors of the company. And then there's a claim for losses for equitable compensation to be paid by those directors straight to Zedra. We say that's just not possible. And Your Lordship, Lord Justice Richards said, what about the information obligation? They're dealt with separately in the prayer at 7 and 8, my Lord. I hope you received by email and by hard copy, respectively, 3 documents, which should be on.
Yes, well, I've got them.
One is the approved judgment of Mr Nabahar-Cookson, QC, in the section 117 application, which you asked for. The second is our.
I'm sorry, and that did what?
That was the permitting inspection of the register of members.
Yes, I've got 2 copies of that.
I've got it on here.
You got it on there.
Yes.
Yeah, so that's the first.
The second is our skeleton argument for the hearing before His Honour Judge Eyre, because it was asked whether we'd taken this point below before His Honour Judge Eyre, and paragraph 49 onwards we deal with the allegations of bad faith and improper purpose. On page 11 of that document.
Sorry about it. Thank you very much.
And paragraph 59, we say we invite the court to strike out the allegations of bad faith and improper purpose with grounds they constitute abuse process and improper pleading, not sustainable face petition. It follows from this that paragraphs 27, 37 and 44 must be struck out in their entirety, and at least in paragraphs 2 to 6 would go to, there being no other basis for the allegations of breach of fiduciary statutory duty. So we were saying the whole thing is unsustainable once you get rid of the bad faith allegations. In the supplemental bundle, you have the transcript of the hearing before His Honour Judge Eyre at tab 13. And at page 163, letter E,
Page, sorry.
163, my lord, letter E.
Yes.
You'll see that we addressed it there as well. With respect to paragraph 44.
There cannot be any question of loss having been sold.
Must be having you suffered, my lord, from so.
Yes, I think so.
Whether I misspoke or was mistyped, I think probably the
I'm
form
sure
was
you
more
didn't
likely.
misspeak in that.
The form was more likely, my lord. And then the final document you have is an alternative ground, an additional ground. We say it's sufficiently covered by our ground 4, but in the event you determine it's not, we advance this new ground, or this additional ground.
And you seek permission to advance that now.
Seek permission to advance that, my lord, insofar as you are against me in saying that the original ground 4 does not cover this.
Right. Well, we'll obviously hear Mr Chasty on that in his submissions. We're not going to call upon him now to deal with them.
Well, my lord, unless I have like to assist your lordships any further, that was all I was proposing to say. Oh, sorry, may I just... My Lord, Lord Justice Richards raised the question of the Companies Act. My junior thinks it's in section 232.
This is on the indemnity point.
Yes, that is the section I was thinking of.
So section 2322, my lord, which directly and direct price indemnity is void except as permitted by section 233, 234, 235.
Yeah.
I'm afraid I haven't been through this.
Yeah.
Thank you.
Yes, Mr. Chesty.
My lords, to be clear at the outset, we do oppose the application to rely upon this ground of appeal as set out in the document that was produced over lunchtime. And I'll explain the reasons why we say that. Lord, to begin with, our concern is that, with respect, if we've not already trespassed, we are, in our submission, very close to trespassing into converting this appeal into a rehearing on the question of the pleadings as opposed to a review. Insofar, I'll concentrate on the back moment if I may. So far as the appeal is concerned in relation to bad faith, and insofar as the application was made in the court below, we have understood, and we say reasonably understood, that the thrust of the complaint was as to the particularity or lack of particularity of the allegation of bad faith. And then the second allegation was that in any event, the allegations, such particulars as were provided, did not themselves give rise to any proper inference of an allegation of bad faith. But what has clearly been sought to develop today, we say for the first time, is a much larger attack on the pleadings, and an attack on the basis that the pleadings failed to disclose a sufficient allegations of unfairly prejudicial conduct, even if, as is required on a strikeout application, those facts are otherwise accepted. We say, with respect, that that is entirely new. Could I just very briefly just try to add a little bit of weight to why we say that? The application, and I'm conscious it's a witness statement, but it does set the scene. The application to strike out was supported by a short statement from a Mr J, which is in the supplemental bundle at page 9. I don't need to read it all because I just need to show you the structure of the evidence that was put forward in support of the application. It begins at page 9. You can see that paragraph 2, he makes it in support of the application, and then he sets out over the page at 1 and 2 some of this the procedural rules. Then he begins by saying, the issues raised at 4 will largely, if not exclusively, be a matter of legal argument rather than evidence. I hope it will assist if I provide a brief explanation as to the basis of the application. Then we have what was the main thrust at the hearing below, but is not troubling my lords at all on this appeal, the allegation that there was an impermissible derivative action. That takes quite some paragraphs of Mr J's statement. And he concludes on this at 12 by saying, in the light of the above, the respondents invite the court to strike out the petition in its entirety. If the court's not minded to do so, it's asked to strike out Zedra's claims for relief 4 and 5 on the grounds that Zedra's claims are derivative claims. The court's also asked to strike out 7 and 8 on the ground that their combined effect is to advance the derivative claim. And then 14, if the court's not minded to strike out in its entirety, is invited to strike out certain other elements on 3 different bases. I summarise below. And then 15, the bad faith or improper purpose allegation. 16, Zedra failed to plead any adequate particulars explaining the basis for these allegations of bad faith and improper purpose. I would suggest the facts pleaded don't properly support or sustain the inference that the respondents acted in bad faith or improper purpose, and therefore contend they be struck out. Then there was a large recurring theme of complaint that there were non-party shareholders whose interests should be taken into account. That as such is not the subject of the appeal either. The judge said that he agreed with our submission. That was really a case management matter as to joinder. And then at 22, reflective loss. So certainly as far as Mr J was concerned, there was no suggestion that there was going to be some larger attack, that the petition itself did not disclose sufficient in terms of allegations of unfairly prejudicial conduct. The whole thrust, my lords, of the application was on remedies and on jurisdiction. But remedies in that strict, narrow sense, we say. In other words, the allegation was, this is a derivative action, or you have no power to make these remedies, not because there isn't a case of unfairly prejudicial conduct made out, but they're too wide and outside of 996. And then the new point was raised on this appeal, which...
But, I mean, sorry to interrupt you so early, but paragraphs 15 and 18 are inviting the court to strike out, aren't they, on the basis of it's an inadequate pleading of bad faith or improper purpose.
Yeah, but on that very narrow point, my lord, the very narrow point that if you're going to plead bad faith, as Mr Ashworth has sought to do, he says
Yes.
you need to give subjective state of mind allegations, or you need to identify the individuals. That was the thrust of that allegation of bad faith, and that's of course why we got into Three Rivers and Keckerman. We didn't get into any of the authorities in terms of what you need to support an allegation of unfairly prejudicial conduct.
I mean, I'm just looking through the transcript of the hearing and searching for the word hopeless, which is ground, I think it's ground 5, ground 3, I can't remember, before us. And it seems that both sides were arguing the case on the basis of whether the pleading was hopeless.
Well, hopeless in the sense of the claim for the relief.
Well, hopeless, actually, just generally.
But it, my lord, is in the transcript. Could I ask you to look just at the top of 163? One has to go back a little bit because he's inevitably the way there is an exchange between counsel and the judge. 63. Mr Ashworth said, in response to some questions that are on the previous pages, that's why I can't say the court can't grant the relief which is sought in this paragraph. I'm not saying that it can't found unfairly prejudicial conduct. And in terms of
that's
the...
at page 16.
Top of 163.
Thank you.
And my lord, we say that if you look at ground 4 for this appeal, it's clear that it's not attacking the fundamental aspects of the case in terms of was there unfairly prejudicial conduct. Ground 4 is simply again talking about the alleged lack of particularisation of an allegation of bad faith and that the facts as pleaded couldn't support an inference of bad faith. That's very narrow. And indeed, in the...
I mean, I don't want to spar Mr Chasty, but at page 202, you say, although it's not mentioned by my friends in their skeleton argument, I doubt there's very much dispute about that. That's why my friend has repeatedly sought to say that our position is hopeless, because he has to say we're bound to fail.
But hopeless in the sense of the relief that we're seeking, because that is the relief that you are seeking. In 163, I think I should have gone on. In 163 at the top, Mr Ashford says, we are back to where we were at the beginning. The remedy for which is, I have to buy your shares, as if I'd not committed those breaches. The thrust was to say, if you've got a relief, a right to relief, it's for a share buyout, but not these, what my friend describes as novel claims for relief in the petition.
Right, you're right, it's centred on the relief.
It is, my lord, exactly so. And indeed, if one looks at the skeleton argument that I think my friend's handed up, he said, allegations of bad faith and proper purpose at 49, he drew your attention to 59. He starts at 49 with a 4-word sentence. This is a short point. My lords, with respect, it took my lords and Mr Ashworth, I think, round about an hour this morning to debate the questions of pleadings in the context of whether or not there are allegations sufficiently pleaded of unfairly prejudicial conduct. So, again, if one reads that in our submission, it is all about the very narrow pleading point of bad faith. It is not about the wider point.
But bad faith, and so you're drawing a distinction between, on the one hand, the pleading of bad faith or improper purpose.
Yes.
And on the other hand, what you have to do to constitute unfairly prejudicial conduct in the sense that you've got to show a breach of fiduciary duty or a breach. That's the point.
That's what I'm doing.
I mean, the submissions that are being made here, I think, proceed on the basis that what is being alleged against the respondents is a breach of fiduciary duty or statutory duty. Breach of duty as directed.
Well, I'm going to take you, if I may, in due course, through the petition. I hope I'll try to do it as not make it as tedious as it might.
I mean, that's what they say in paragraph 45 of the.
But we do say the petition shows quite sufficiently and adequately allegations of rights and entitlements as a consequence of either express rights or implied obligations that arise out of the understanding that existed, which have been infringed, and we say give rise to unfairly prejudicial conduct. But I put it at its lowest. We say it was not suggested to His Honour Judge Eyre that that aspect of a case of under 994 wasn't sufficiently made out. And you can, in our respect, really see that from his paragraphs 80 to, I think, 85, when he's dealing with that. He's dealing with this whole question of Three Rivers and the adequacy of the pleading.
Mr Chasty, could you just cut to the chase, no pun intended, and just tell me why you say the point that I put to Mr Ashworth on paragraph 44 is wrong. In other words, why is it sustainable to say that because they allotted shares to 13 other people apart from you and didn't include you, that is unfairly prejudicial?
To cut to the chase, my lord really said you joined up the dots, but you did, we don't think that he's joining up. We say the position is very simple. We say, if you look at the petition, if you look at the whole of the petition building up to paragraph 44, in particular paragraph 16 to 20, the petition sets out the rights that Zedra asserts it held as a shareholder. Those rights included an entitlement to be kept informed as to what was going on, if I can put it bluntly like that, to be kept informed of proposals which would or could affect its position as a shareholder. So that you have, I'll summarise it and then I'll take you to the detail. So it had rights to be involved, to be provided with information, to monitor its shareholding, and armed with that information, it would have been then in an informed position to make decisions as to what it wanted to do. We say those allegations of rights established in that way were not the subject of any attempt to strike out. Based upon that, we say it's very simple. The evidence, we say, is sufficient to show that a concerted decision was made to exclude, deliberately, Zedra from that process. As a consequence, Zedra's rights, A, to buy some more shares, which is sufficient in itself, were infringed, and its rights arose from its entitlement to know what was going on. And secondly, it had, as a 10% shareholder, as again is pleaded, certain entitlements to participate in the event that there were attempts to deal with the articles in a particular way or to change the articles. The fact that it wasn't told and therefore wasn't able to participate in these acquisition of further shares, but other third parties were, meant A, it didn't buy more shares, which is bad enough in itself, and C, its 10% proportion dropped below 10%, thereby losing those entitlements that it otherwise would have enjoyed as a 10% or more shareholder. That, in essence, my lord, is what
so if I understand all that, so let's just assume now for a moment that you had been told,
yes,
and then the company had decided to sell shares to 13 other people in the way they did. Would you have a right to say that you'd been unfairly prejudiced?
Well, it would depend why we'd be told we couldn't do it, I suppose. But if we come along and say, as we say we're entitled to...
Well, my point is the bidding process. When a company raises money, particularly a successful company, bidders abound and they desperately want to... Investment bankers from all over the world make phone calls and say, for goodness sake, let me invest. I'll give you a much better valuation than these other people are giving you. How much? What's your best valuation?
Yeah.
All that stuff. That goes on. Surely the company is entitled, the board is entitled to decide who it wants to invest.
But not necessarily at the expense of allowing me at least to engage in that exercise.
I can't see what loss you've suffered.
Doesn't that presuppose you have a right to do so?
Well, my right is a right to at least participate in the exercise.
Where is the right to be found?
What we say, my lord, if my lord looks at paragraph...
When you say, sorry, I cut you off, I thought you were saying you had a right to participate in the share issue.
No, I have a right to participate in the sense of knowing what's going on and then putting my head forward and saying I wish to
we're proposing to acquire a business, as they acquired Microteam.
Yes.
Proposing to acquire a business in consideration of an issue of shares valued at £50 million, let's say. Would that give you a right to participate in that share issue?
My lord, I can see that could be a different scenario from the one that I'm postulating. Is presently postulating.
You're not postulating.
Yes, you're not actually postulating any scenarios in the petition. That's the difference.
Well, we are, my lord, in our submission. First of all, can I say I'm already being, if I may respectfully say, dragged the wrong word, but I'm already now seeking to justify
you are being dragged into the substance of this case, but
which is not the ground of the appeal
but
that I'm here to
Chastey, we will decide in due course on Mr. Ashworth's application to add a further ground of appeal. But I just asked you, what's your answer to it if he's allowed to add it and if he's allowed to raise it?
Then my lord needs, rather than me trying to summarise, can I take my lords to the petition?
Yes.
It makes sense that I do that.
Yeah.
So you can see, my lords, that I have, starting at paragraph 99, you can see that the first paragraphs are introductory. And then I should add that
page 99.
Page 99, yes. And then you can see, just to deal with points as I go along rather than come back to points, if I'm going through this once, it's probably better to do it once, if I may say. So at paragraph 8, I set out the names of the relevant respondents, and there are 14 of them in addition to the company, and it has the dates during which they are directors. So it's not difficult to cross-reference subsequent events to the period of time that those individuals were directors. Paragraph 9 sets out the statutory duties. And then you can see we have the transaction itself at paragraphs 10 and 11. At paragraph 15, you can see that there is then a 13.2% issue to Zedra. Then at 16, we set out what we say are the rights of Zedra. So the SPA is more particularly set out at 11 to 13. As a result, as part of the consideration for the sale of shares, Zedra had the right to receive dividends from the consideration shares in amount commensurate with the number and value of the shares relative to the overall issued share capital, and that Zedra's rights as a shareholder would be protected by Mr Cookson's participation as a member of the board, so that Zedra had a legitimate expectation at completion that the company and its directors would not take any step after completion which unfairly diluted the size of the shareholding granted to Zedra. A shareholders' agreement relating to the SHH to which Zedra became a party, the company's articles. Under the SHA, Zedra qualified as a substantial...
Can I just ask you, just pausing, the 16.12, this is really a point of detail, but I just want to get it right, says that the SPA, that's the share purchase agreement, which we don't have in our papers, as a result, you say, Zedra's rights as a shareholder would be protected by Mr Nabahar-Cookson's continued participation as a member of the board. Now, I mean, I think, did he have a right to a position on the board?
I think the SPA does provide for that, yes.
For him to be appointed?
Yes, for him to be appointed.
And he was appointed?
And he was, but then... there was
subsequently resigned.
There was a fallout.
Yeah. I mean, there is under the article, I just want to get this straight, there is under the articles rights conferred on some shareholders in certain circumstances to appoint directors. Are you within any of those?
Well, he had a right to be under the SPA. Yes, it's Zedra that had the right to appoint its director under the SPA. Would my lord find it helpful to be provided with a copy of the SPA?
I think, yes, it would. Yes, it would.
I was going on, my lord, at 17.
I mean, while we're there, I did make a point to Mr Ashworth this morning that that the so that Zedra had a legitimate expectation didn't really add anything to the general law as set out in section 994, did it?
One always seems to plead a legitimate expectation.
Well, you
even
shouldn't
now in
really in this sort of case, I'm not sure, I think, but a legitimate expectation not to be unfairly prejudiced, that doesn't add anything, does it?
No, I think not.
All right, that's fair enough.
I'm not sure that that's quite how it's being put in terms of 16.12. It's more a legitimate expectation that steps would not be taken which would alter its Zedra's shareholding.
Doesn't say that.
Well,
I mean, it says which unfairly dilute.
which Lord,
So it's unfair.
unfair.
Yeah.
Lord.
I mean, dilution is absolutely normal in this.
Well, dilution, I accept, is perhaps not the entirely best word to have used in terms of the petition. What my Lord asked me to cut to the chase. In terms of the question of the shares, what I've said is that we were denied the right to at least participate in the question of whether or not to acquire shares. We were just cut out of that exercise at all. We didn't have an opportunity to put ourselves forward and argue our case as to why we ought to be entitled to buy some of the shares. And then at 18 is important. The company undertakes to prepare and deliver to each substantial shareholder the following information: a notice of each meeting of the board or any committee of the board, specifying the nature of the business to be transacted, together with copies of all documents and other information given to the directors in relation to the meeting at least 7 days prior to a meeting, minutes of each meeting of the board or any committee of the board as soon as they become available, any other information which the shareholder may reasonably require for the purposes of monitoring their investment in the company. Pursuant to clause 6.1, each of the shareholders undertakes to the company and other shareholders that he shall, as far as possible, procure and at all times exercise his voting rights as a shareholder and director, and otherwise act so as to procure the proper maintenance and observance of the terms of the SHA and the articles. And then there are further references to covenants, and in particular the rights for shareholders of more than 10%. You can see those are set out in 20. And we say then at 21 and 22, on the true construction of 4 and 6, the company and its director shareholders are each bound to disclose and not withhold from Zedra, as a substantial shareholder, such information as it reasonably required for the purposes of monitoring the value of its shareholding, including but not limited to the information in 4 and 4.2. Alternatively, such obligation is to be implied. Accordingly, insofar as any action proposed would have resulted in the voting shares falling below the 10%, so as to deprive Zedra of those rights, any shareholders and directors aware were bound to disclose it. So when we get to 44, what we're saying is that, and I'll come back to the words bad faith and improper purpose, is that steps were taken, and I take my Lord's point about the use of the word dilute. And then particulars are set out. And one, on a date unknown and without notice, unilaterally elected to disapply the information obligation. So we just weren't told, and we go on to say that a letter...
So you're
I'm sorry, I'm at 44.1.
41.1. 44.1.
2, the directors deliberately concealed relevant information by wrongly withholding inspection. 44.2 did not offer Zedra the opportunity to participate. Specifically, during the period of the share issues, failed to make any reasonable inquiries as to whether wished to subscribe. Had such been made and had the shares been offered at an affordable price, Zedra would have elected to participate. My Lords, in terms of that allegation, that's important. We're saying, so we were denied the opportunity to participate against our rights to be informed, we say.
How does a right to be informed translate into a right
forgive me, I'm using we had the right to be informed.
Yes, okay.
We then had the entitlement to consider what we wanted to do with that information.
Well, I mean, maybe you did, but the fact of the matter is that this sort of takes leave of reality. I mean, in reality, valuable tech companies going places are falling over themselves with investors wanting to invest. And you need a right as an existing shareholder in your shareholders agreement when you invested to be given the right to invest as against the board deciding that somebody else may invest, because investments are regarded as extremely valuable, and everybody knows that the price value of this company could go up hundreds of fold, which it appears to have done. So it's no good saying you had to tell me, because the consequences of not telling you is a lemon. It's nothing.
Well,
it's just you couldn't have done anything because, as you have already pleaded elsewhere, they didn't want you to have any more shares.
well, the interesting point, though, my lord, is the way that the defence deals with this allegation. We haven't looked at the defence, but the defence at 137, at paragraph 3, says it's admitted that the directors didn't offer Zedra the opportunity. It's denied that they were obliged to offer Zedra any such opportunity or make any inquiries as to whether it wished to subscribe. Well, we say that...
So this is a
Sorry, it's
paragraph...
137. It's the paragraph numbered 3 on the page 137. So
Oh, I see. So it's paragraph,
paragraph 60.
63.
60 brackets 3. So just going back, if I may, my lord, it says it's admitted the directors didn't offer the opportunity. It's denied that they're obliged to do so. Well, we say there's a battle about that.
Well, where is the obligation? I mean, you don't plead an obligation to offer Zedra an opportunity to participate in the share issue.
No, I plead that I had an obligation to tell me about it, and I would have participated.
No, but sorry, that was
I
what my
appreciate
lord
that's
was
different.
making. How does, I mean, they accept, they denied it. It's alleged that they deny that the directors were obliged to offer Zedra an opportunity to participate in a share issue.
No, they deny that they had or to make any reasonable inquiries as to whether we wish to subscribe.
Yes. Well, I mean, you don't plead any basis for suggesting that they were under any such obligation.
Well, I pleaded in terms that they are obliged to give me any information that might affect my shareholding.
I understand that.
And that I'm entitled to monitor my investment.
I accept that.
Yes.
So they inform you that they're proposing to issue shares, let's say, in consideration of acquiring a new business.
Yeah.
So they're going to issue those shares to the sellers of the business.
Yes.
Well,
they don't.
What right to participate in that share issue would Zedra have?
I have a right at least to put myself forward and make offers, and they don't deny. Can I just continue with the defence for a moment? Because you'll see.
Well, but I don't understand how you can put forward an offer to sell something you haven't got.
No, to participate in the shares that are being offered to other people. I would have wished to participate in that effort.
But all right, Mr.
And I would have bought shares.
Supposing you do wish to, but I mean that you might wish to, but you had no right to do so.
But my lord, they don't. The only way they deal with it is this. If I just be allowed to carry on, they say the phrase "affordable price" is embarrassing. The directors reserve the right to plead to the same when Zedra set out what the affordable price was. 2, the meaning and significance of the phrase so as to maintain its financial interest is not understood. C, to the extent that the allegation that it contains is understood, Zedra is required to prove that it would have so elected and had the financial means to do so. They're not actually challenging, other than to put me to proof, that I would have been able to acquire some more shares.
I think they are in the previous sentence.
Which one, Lord?
Well, the second sentence of 3.
Of 3?
16.
It is denied.
It is denied.
Respondent directors were obliged to offer Zedra such an opportunity.
Yes, I appreciate that. I appreciate that it is denied that they say that they had to offer me the opportunity. We're talking about an opportunity, but they also say they deny that they had to provide me with information as to reasonable inquiries.
I mean, the normal
that's a
position,
dispute. There's a dispute.
Chastely, the normal position in this kind of situation is that when you invest in a startup or a company, you enter into a shareholders agreement. And the shareholders agreement specifies the rights to which you're entitled when further investments are made. Because many investors, I mean, we're talking here about equity funds normally, who are very astute to protect their interests if their investment is a good one. And so they put in those agreements a right to participate at the same price as the other investors in a further offer.
Yeah.
Now, that didn't happen here, I take it. There was no right for you, Zedra, to participate in further financings.
No, not certainly not a pleaded. I accept that.
No.
But
So what you're trying to do in this case is create a right that wasn't originally granted.
my right, I say, I've established. My right is to be kept informed, and from that, I will do with that information as I can. And we say, have put our head above the parapet with a view to seeking to acquire some more shares.
My lord put it to me a moment ago, privately, but I'm afraid I'm going to disclose his confidence. He said, well, is this a loss of a chance? But what do you say about that?
It's certainly a loss of the opportunity, which we say we would have.
You can't have a loss of a chance, can you, without a right having been broken?
But my right is to have the information. That's what I stress. And then I say I would have used that information in a particular way. And I say, although they deny that I would have had the right to that information, but that's for a trial to establish. That's not a strikeout ground, I submit. But then they go on to say, well, prove it. Prove it that you would have done the things that you say you would have done with that information. That's as far as they go. That's as far as they go. They just put me to proof of it.
But it's a little unrealistic to have a trial about a case where that you're all at odds with one another, you've fallen out irretrievably, you've been litigating like Billy-O, and you think they were going to do anything to help you, but they obviously weren't, unless they were obliged to.
They didn't apply for a summary judgment based on evidence to say, this is all a lemon, because it's not going to take you anywhere for these reasons. They said, we put you to proof on it.
No, but I mean, we have to consider, I mean, I know you're resisting strenuously, and I quite understand that. We'll just hear you on this, any amendment to the way the claim is put. But if we were to conclude that this is a hopeless claim and could not succeed, then it's rather better to put it out of its misery now than let it go to a 6-week trial and come back in 2 years' time and then put it out of its misery.
It depends whose perspective on us, that question. But my lord, it can't be characterised in our submission as hopeless, not on the current state of the pleading. Okay. Can I say why? Can I just continue why we oppose this ground being brought in? Because a fundamental point, of course, is the evidence, the basis upon which the case was being advanced below, and until about 35 minutes ago, whenever that new ground was eventually surfaced, was that this was not a point in issue, in the sense that it seems to be developing. Of course, one point that would have happened if this had been brought before His Honour Judge Eyre, which we say it was not, is if His Honour Judge Eyre thought there was some substance in it, then, of course, he would not necessarily have struck out this point without first giving my clients the opportunity to consider amending any perceived defects. That, my lords, is the point that I think, if my lords, I can deal with the point quickly. It's in the white book. If my lords wish the reference, it's page 128 under paragraph 3.4.2, and it says that where a statement of case is found to be defective, the court should consider whether that defect might be cured by amendment, and if it might be, the court should refrain from striking it out without first giving the party concerned an opportunity to amend. That's a High Court decision of Sue Kim against Uke, 2011.
It's a decision of mine, Mr. Chase.
Ah, my lord, was ahead of me on that. In which case, I fully commend my lords in the expectation and hope that that is an accurate summary.
I'd just quite like to look
and that the Supreme Court affirmed the decision below.
Page 128.
Yes.
Which paragraph?
Sorry, my lord.
On the page?
Sorry, forgive me.
That's all right. Because this is all text, so
It's towards it's the paragraph. It's about fifth of the way down, where a statement of case is found to be defective. The second.
Oh, yes.
And, my lords, we say that this is important to this question of whether or not it's proper for this point to be raised now. The case, one of the cases that is in the bundle, this was in the context of another new point that at least we had a little bit more notice about, that the appellant wished to raise in the context of human rights, was the case of Singh against Das. And this is in tab 5, my lords. And at paragraphs 15 to 18...
We're in tab 5 of the authorities.
My lord, yes.
We'll have a page.
I'm afraid I don't. I'll get that in a second.
What's the... Okay, I can find it.
It's
Avatar Singh.
Page 72.
72 of the PDF.
Thank you.
And if I imagine it's about 3 or 4 pages further on, you will have paragraph 15.
Got it.
The following legal
Justice Haddon Cave.
The following legal principle apply where a party seeks to raise a new point on appeal not raised below. First, an appellate court will be cautious about allowing a new point raised that was not raised before the first instance court. Second, an appellate court will not generally permit a new point to be raised on appeal if that point is such that either it would necessitate new evidence or, if it had been run below, it would have resulted in the trial being conducted differently with regard to the evidence at the trial. Third, even where the point might be considered a pure point of law, the appellate court will only allow it with the 3 criteria. The other party has had adequate time to deal with the point. Will make their own decision whether we've had sufficient time to deal with the point as it's been raised. The other party is not acted to his detriment, and the other party can be adequately protected in costs. There are a number of matters there rolled up, my lords. If this point had been advanced in the way that it seems now to be being advanced, especially, my lords, if one is going to say, well, look at the reality of what would have happened, as my lord said, it'd be hopeless. You wouldn't get anywhere just if you raised your head and sought to ask. That seems to us more summary judgment territory rather than strikeout territory as such, and therefore evidence might well have been in. I've already made the point that what would have happened is, in all reality, is the judge would have said below, I'm minded to strike this point out for the following reasons. We would have said, well, please stop and allow us the opportunity, look at page 128, to consider amending. And that's not a realistic way to deal with this appeal. It would be unrealistic for us to expect, and we shouldn't be denied in our respectful submission that entitlement. It would be unrealistic to expect us to do that with this court and to come back and then go through the same exercise that we would have done with His Honour Judge Eyre. And so far as not acting to his detriment on the faith of the earlier admission, well, we haven't come to court today with any fallback position, as it were, any alternative Sue Kim type position to say, as we might have done if this had been foreshadowed some time ago. And so we have acted to our detriment in that we have proceeded on the understanding and on the basis that this pleading point is an extremely narrow one. So we say that you shouldn't, in our respectful submission, permit this to be allowed now at this late stage in this way that it's surfaced. The grounds of appeal, ground 4, do not come anywhere close in our respectful submission as presently formulated to this point. And what appears to have happened is that during the course of exchanges early on this morning, from the Lords and Mr Ashworth, a point was made questioning whether the allegations of unfairly prejudicial conduct themselves look sufficient, and the appellant has developed from that initial introduction, as it were, and this now seems to be the main thrust of the case. This seems to be the main thrust of the appeal, which, in our respect submission, is extraordinary, and would be an extraordinary basis on which to decide the appeal.
But I mean, looking back at 44, I still don't, I'm afraid, understand how paragraph 44(2) supports an allegation of bad faith or improper purpose against any director.
Well, that, with respect, would be a different point. At the moment, I was dealing with this question of whether or not there is an allegation of unfairly prejudicial conduct.
I see.
Because if
But
one...
sorry, I mean, it does go together, because if there isn't an obligation, that's the difficulty about 44.2. If there's no obligation to offer an opportunity to participate, then it becomes extremely difficult to see where the bad faith or improper purpose is, which is why it ties in with saying that unfair prejudice would take the form of breaching your rights under the articles of the law and so on.
Well, for all the reasons I've said, and as are foreshadowed in paragraph 16 to 20, I think, we say there is an obligation. There is certainly an arguable obligation of an opportunity to participate.
You say what it says is the directors did not offer Zedra the opportunity to participate. I.e. the opportunity to take up shares.
They denied us the opportunity to participate by denying us the information.
No, they denied you the opportunity to further. They denied you the opportunity to participate in the share issues, pro rata or at all. So, I don't understand, as I say, how that demonstrates bad faith in the absence of an obligation to offer.
Well, I think what we're saying, my lord, is this: that the obligations clearly need to be looked at in this role. This is rolling up, I accept that. But we're saying that you have an entitlement to information, and then you have an entitlement to be told what it is that they're proposing to do.
Yes.
And what you do with that, and that really is what it is.
No, but you're not, the pleading is a failure by the respondents to do that which you say they ought to have done, isn't it?
This, my lord, if one had been facing, I may say, if one had been facing this level of critical analysis, this line-by-line analysis...
Well, you say line-by-line, but remember we've just got a bald allegation of bad faith, and then we've just got what we see on page 114.
What I was going to say was, my lord, if His Honour Judge Eyre had been invited to do this and expressed concerns as to that formulation and felt that the words needed to be refined in order to address the question not so much as the directors did not offer the opportunity to participate, but the directors did not deliberately fail to provide information which would have enabled the Zedra to participate in the following way, and one can see how that might develop.
But that's a completely different allegation. This is a 44.2 is really the crux of your allegation of the shares being issued in bad faith or for an improper purpose.
We say 44.1, 1 and 41.
Well, that just meant they didn't tell you what they were doing.
Exactly.
We assume for the moment they should have done.
Yes.
But that doesn't make the issue of shares either bad faith or improper, for an improper purpose.
No, but if we've been provided with the information as to what they were going to do, as I say, Lord, this doesn't really benefit from repetition, but it really is what is at the heart of what we're saying. And as my Lord Master of the Rolls saying that he was joining the dots really articulated what is 44 is about, is that if we had been provided with the information which we say we should have had, then we would have sought to engage within the process. And we say we would have engaged in the process, and they say, well, we put you to proof about that. They don't put forward an alternative positive case against us.
You don't. It's true, isn't it? You don't actually take issue with any of these share issues. You don't. It's not part of your case that any of these share issues were an undervalue, not, and so on.
No.
So they were all proper share issues.
If we're just done in...
So far as your case is concerned.
We make no allegation as to the individual transactions themselves. It's just the fact that we're not a party to any of this. That's the point.
So why does that evidence... I don't understand why that should evidence an attempt to exclude you or dilute you.
Well, if you don't...
Because after all, the other directors may not have taken up shares in these offers either.
But the mere fact that that's...
I mean, if they were buying a business
may have had the choice
from a third party, necessarily that would be the case, wouldn't it?
Yes, but at least they may have had the choice and their rights, and we assert that our rights are what our rights are as a shareholder.
Which is to receive information.
Yes.
Nothing more.
Well, it follows that we say we would have done certain things with that information, the denial of that information, and therefore the
And
infringement of that
what
right.
you say you would have done is assess whether this was a time you would like to invest,
Yes,
and you would have gone to the board with a proposal that you be allowed to invest.
yes. And all they say is prove that. They don't say no, you would never have been able to achieve that aim that you assert you would have sought to achieve. That would have to be summary judgment territory, and that would mean some evidence.
Well, you may be right, but at the moment I have great difficulty with the commercial reality of this case. I mean, you accept you didn't protect your position when you invested by having a clause in your shareholders agreement allowing you to invest in the future. That means you, like every other investor, knew that you were likely to be diluted by future share issues when other people invested. The only right you assert is to have information. You were getting information at a time when everybody hated one another, apparently accepted. We can read Mr. Justice Blair's judgment. So yes, you might be entitled to try and prove that had you known, you would have gone to them and all fallen back happily together, and you would have made a bigger offer than the people actually investing. But none of that is even intimate, none of that is even sort of suggested in the pleading. It's not what you're saying. You make it look as if it is your right to invest, not just your right to be told you could invest, because sub silentio, one is allowed to say that. It's perfectly clear from the document that you know they wouldn't have allowed you to.
That's not what they say. They just say prove it. So we're not saying anything extraordinary. My lord says it lacks complete commercial reality, but they don't say that. The defendants don't say that.
Well, I agree they don't say that. But,
And if that's their position, if their position is go to court and prove that, that's where we've stopped.
But they don't. They deny.
They
And that's
did-
the point. They do deny that they were obliged to offer you any
yes.
such opportunity.
Yes.
And they deny that they're obliged to
But-
make any reasonable
but
inquiry.
that's
So
the-
how does 44.2 in those circumstances, 44.2,
Yes.
indicate bad faith?
Well, that's just that's what I attempted to answer before in terms of the rolled up nature of these obligations, which we say exist from 16 to 20. And if my lord feels that the matter could have been differently pleaded, then that
I'm not actually
No, no,
thinking that at all.
no.
I'm just looking at your
I understand.
pleading, seeing whether.
But my lord, that is a debate, a discussion which would take place on a strikeout, and that's why we say this is entirely unfair on my client to be
Is
having
it?
this
Because
debate.
I mean,
now.
what was put to the judge, and I think really what is put to us, is that what is in 44.1, 2, 3 and 4 cannot amount to a pleading, cannot support a pleading of bad faith or
Yes.
improper purpose.
That's bad faith or improper purpose. What I'm
Exactly.
saying is,
Exactly.
but look, if you were to strip out, my lord raised this question earlier about bad faith and or improper purpose. When Mr Ashworth was ready, you made the observation that paragraph 44 says acting in bad faith and or for an improper purpose. His Honour Judge Eyre put those two together.
Well, having been
but-
shown paragraph 80 of the judgment, I can well understand what the judge was saying there.
But what I would say is, and I would say that this would be a supportable position to adopt, is one can have, if the pleadings are being attacked and a court reached a conclusion about the pleadings being incapable of being saved, then one could have justifiable fallback positions. My first point is that my primary position is that the pleading is sufficient. It's adequate and it meets the test of Three Rivers, it meets the Keckerman type test. In other words, a balance has to be struck. My clients have not yet had the benefit of disclosure. They do not have witness statements. There is a degree of irony, of course, to some extent, in it being said by way of criticism that my clients have not provided enough information when our basic case is that we have been deliberately denied information. So there is some tension between an assertion that we should say more when we're saying that we've not been given enough, and that's our basic case on this point. But that would be our primary case. But again, it goes back to this point about saving the pleadings, as it were. If it was necessary, if the court said, no, this is all about bad faith and the need to properly particularise bad faith, one could blue pencil the words bad faith, and one could be left with the allegation of improper purpose, which would not require proof of fraud or dishonesty. Or at most extreme, one could strike out both of those, bad faith and improper purpose. And one would have the company and its directors have taken steps to dilute the minority shareholder, which is in breach of the duties, or it could be said, which is contrary to the legitimate expectations set out at 16 to 20 above.
Well, that takes you back to unfairness.
Yes.
I mean, now you're putting forward a quite different case.
I'm not seeking. What I'm seeking to do, my lord, is simply to demonstrate that we say that the unfair prejudice allegations, which I repeat, my position is that it's unfair on my client to be having this debate in this way, and it's extended beyond the narrow approach that's been adopted on this appeal. But I am where I am at the moment.
Well, it is quite a good analysis of what the claim is actually all about, which is, I think, what we're interested in.
Yes.
I mean, the point that I was going to put to you is that I understand the point about the failure to provide information, and I understand what might be called the elision in the pleading that
Yes.
then takes that to, well, we were denied the opportunity to participate. But if that's the core of the claim, why do you need bad faith?
Well, there
That's
could be
the
an
thing
argument.
I've
There could
been
be an
puzzling
argument.
over.
That's why I said if the words bad faith were struck out, the case still hangs together.
Well, I have a little difficulty with that.
Well,
I mean, two
that's
points really. Your first one is you strike out bad faith. Now, the judge said that on this pleading, there was no difference between bad faith and improper purpose. He could conceive, as we all can,
Yes.
circumstances where you can have an issue of shares
Yes.
for an improper purpose, where the board genuinely believes they're doing the right
Yes.
thing, but actually it's for a wrong purpose. But he said on this pleaded case.
Yes.
Now, was that a submission you made to him?
I don't believe I did, in fact. No.
But I mean, when I read that, having raised the and/or point with, with Mr. Ashworth,
Yeah.
when I read what the judge said, I could see why he was saying that actually this isn't a case where it said that the directors believed they were doing the right thing, but actually the purpose was not a legitimate purpose.
But a party could be subjected to unfairly prejudicial conduct, of course, without the wrongdoer, if that's still the right word to use from what I'm going to say, not acting in bad faith.
If you struck out the words acting in bad faith and improper purpose, which I think was your third alternative, I mean, the pleading does, on any footing, fall to the ground, doesn't it? Because you go on to say it's in breach of their statutory duties, but how can it?
No, I follow. I intended to follow. I thought I followed on.
So your third, yes, you wouldn't strike out both. You would strike out one of them.
Well, you could, if you struck out both, I accept that breach of the duties, the statutory duties, would possibly go, subject to 172 in good faith being assessed on a subjective basis or objective basis if no thought was given to it at all. But without going down that road, it would still hang together, I'm saying, and this is the sort of conversation I'd have been having, as it were, with His Honour Judge Eyre, by going back to this question of what were our rights in terms of what were our entitlements in terms of being provided with information. And certainly 44.1 brackets 1 and 2, we say, would it alone be sufficient to justify the allegation of unfairly prejudicial conduct? I've sought to answer a case for the last hour, my lords, as the one that I didn't know that we were going to be met with. So there is, I would repeat, a serious artificiality about the appeal at the moment, from the appellant's perspective as well as mine, in that they are advancing points that were not advanced before His Honour Judge Eyre. And insofar as this is a review of his decision is being considered in respect of points not advanced to him. Insofar as the points that were advanced to him are concerned on pure pleading, because I repeat, majority of the day was spent arguing about derivative and whether this was a derivative claim, which has not been pursued. And then reflective loss, which it was nonetheless pursued, notwithstanding our point that we're not saying the company suffered any loss. And then the main point was that these claims were being brought against shareholders who were not parties. That too formed a large part of the argument on the strikeout. So none of this appeared at all. I've just been handed a point. In terms of failure to provide information, this is something that there is a line. There would be scope for arguing in any event. Just pausing for a moment as to breach of the duties. Again, I would perhaps need to think about this more fully, but it's something I would have done if we'd had more opportunity. There would certainly be some scope, I think I'm right in saying, that whether it be under 171 or 172, a failure to provide information itself could be potentially a ground of breach of those statutory duties. Certainly to the company, but I'd need to think about that a bit more carefully. I'm just noting something that's passed up.
Yeah.
But if I could just return then to the case that we thought we were coming to meet in terms of pleading, the case that we thought we were coming to meet in terms of the pleaded allegations about bad faith was solely whether or not the allegations were sufficiently particularised. And I can do that quite quickly. In terms of that, we say that the Three Rivers Authority, Lord Hope makes the point that there is a balance to be struck between providing sufficient for a party to know the case they have to meet and expecting the party making the allegations to provide a mass of particulars of those basic elements of the case. Now, we say that the judge below was right to say that they know what the case is that they're being required to meet. And the balance is fairly in our favour because of our lack of information. This is not Stanford at the moment, because in Stanford, of course, as my Lord Master of the Rolls made the point, that they said we've come to the end of the line in terms of any further particulars. And indeed, I think I'm right in saying within the liquidation proceedings that had foreshadowed the issues before this court, they had been provided, the claimants had been provided with quite a substantial amount of witness statements, I think it's right to say, or reports based on investigations. We've got nothing like that at this stage. We have no disclosure, we have no board minutes, we have no emails or communications between any of the relevant directors. We have no witness statements.
But it's a bit unsatisfactory, isn't it, for him to have to file now 14 witness statements from all the directors simply saying, I didn't do anything in bad faith. Disclosure will come first, and it may well be that based on disclosure, we will be in a position... You still haven't had disclosure? No. Everything stopped. That's the unfortunate thing here, that this strikeout application was made 2 or 3 months before we had a case management hearing listed. And, of course, all those matters would have been dealt with there. But the application was issued, failed, and then the appeal was launched, and a practical view was taken that the appeal needs to run its course, or else we just have the unsatisfactory position. So we haven't had disclosure. As a matter of interest, why is the appeal taking so long to come on?
I can't answer that, my lord, I'm afraid. I have no idea.
Right, shouldn't have done.
I don't know whether the appellant's better placed to answer that, but it has taken an extreme... We would have had a trial by now if this matter had been allowed to just run its course, and all these matters would have been dealt with. So
that's what I had in mind this morning when I was early on pointing out that it seemed a bit odd to me that we were arguing about the pleadings 2 years down the line in the Court of Appeal.
Well, I would certainly share that view and probably add a little more, but I think my lords probably know what that would be. It's entirely inappropriate that we should be doing this, and we have not put any further pleadings in a bid to try to satisfy the claimants to back off on this appeal, because we understood the grounds of the appeal on the pleading point to be narrow, and whether we proved right or wrong, we felt comfortable in our position based upon what the judge has decided, and based on Three Rivers and Keckerman and the early stage at which we'd reached. And then when we received Stanford, I think yesterday or the day before, we looked at that and felt that that too was not really something that really assisted in the determination of this narrow pleading point. So we have, it might be said, lost 18 months or whatever it is. And that's, we would say, not the responsibility of Zedra, because we didn't know this was going to be advanced in this way. And the laws have got all those points. So on the narrow point,
but just to be clear, you are not saying that you want an opportunity to amend this pleading even now?
No, my lord, I would say that if my lords said, you're going to strike me out based on this current pleading, and you set out and you told me the reason why that would be, I would say that I would then be afforded an opportunity, or would be asked to be given the opportunity to meet those identified deficiencies. What I say, though, is wrong, and why I say that my lords shouldn't be doing this at all, if I may say, is it's not in our submission for this court to be engaged in this kind of exercise. It's not for this court to be spending a whole day going through these pleadings in this way. And then, I don't know what would be proposed, my lord.
But if we form the view, I mean, you can't negotiate with the court,
no.
Mr Chasty. No. If we form the view that the case is hopeless as pleaded, and that is, at least on one analysis, one ground of appeal, then we would have to strike you out, wouldn't we?
If you said it was hopeless as pleaded, I would say, afford me the opportunity to correct the defects that you identify as existing.
Well, okay, but I mean, I would have thought it would be quite useful in your submissions to explain how you can correct the defect that I put to you early on in your submissions.
Well,
because that, I mean, I understand the causation point. I understand you say I need to be entitled to have an opportunity to show that if I'd got the information, I would have been able to do something. But that could be pleaded. It's not at the moment. But I don't think you're saying that you did have a right to invest under any of these 13 share issues.
I think I've put my point as best I can in relation to my entitlement to be given the information to make my informed decision to participate. But going back to my lord's point, I'm not seeking, my lord, nobody would remotely be suggesting we're seeking to negotiate with this court. What I'm merely saying is this. This is a point we say has been raised an hour and 5 minutes ago, effectively. It was not raised before. That in itself, in our respectful submission, is a good reason not to allow that ground of appeal to be pursued, because what it denies me is the opportunity in a sensible, meaningful way, not on my feet, not even
overnight. You're going to have a
overnight.
sensible, meaningful opportunity tonight to think about it overnight and come back with any answers. I mean, it's a pretty simple point, isn't it? It's a pretty simple point. I understand it wasn't the focus of the argument before the judge, but it was in there somewhere. That this was bound to fail.
It was so deep, my lord, I didn't see it. I didn't find it.
I mean, I understand what you've said about derivative claims and reflective loss being the main focus, but there was another point there, which was that bad faith didn't get you where you wanted to go, and it wasn't properly pleaded, and that it was all utterly hopeless.
Well, sorry, my lord. It was bad. What was utterly hopeless were the remedies that we were seeking. And it said they were utterly hopeless because I was pursuing a derivative, or I was pursuing a claim for reflective loss, or as Mr Ashworth said, as noted in paragraph 92 of the judgment, for the first time orally, in oral submissions, the court had no power to grant these remedies. That's in our submission, my lord, what was being characterised as hopeless. The remedies, not the underlying allegations of unfairly prejudicial conduct. That, my lord, in our submission just never featured. And my lord says it was there somewhere, but this has been the only thing that effectively they've argued today. So it was not in our submission there in a procedurally fair way for us to be expected to deal with it. And, my Lord, I would respectfully say that even saying you've got overnight to come with a new pleading wouldn't be.
Nobody's saying you have to come with a new pleading, but you do have overnight to think about what your answer might be if you wanted to come with a new pleading.
Well, my Lord, I understand that. But I won't force the point any further than say this, that we would say we shouldn't be in a position as a result of this being raised at the last minute, and I take you to DAS and sing, that we are effectively seeking to do that in order otherwise to save this case. That should have been done back 18 months ago, or should at least have been in the grounds of appeal that were themselves issued 15 months ago.
Instead, 3 of the grounds of appeal are about a point that never arose before even the judge.
Well, I agree with that as well, and that at least we had some prior warning about that one. I would have had
replaced the Duff argument about the derivative action. I mean, one can't help feeling about this whole case that it's a bit like this, that nobody's engaging with the other at all.
Well, I get hit with an application which we respectfully say is Duff. Derivative was the main basis of their application, then reflected loss, and then this bad faith point. We did not ask for this case to be put on hold for 18 months. And then when the appeal is launched, we find for some reason this killer point apparently about human rights, which never ever featured ever. And one wonders, with respect, how far that influenced the granting of permission in the first place, in terms of seeing such a fundamental point being made, and whether we would have been here but for that. But that, if I can use my Lord's expression, is and was a Duff point. And then from the perspective of my clients, to be then facing today arguments about whether or not paragraph 44 shows a sufficient case of unfairly prejudicial conduct. I hope my Lord can, from my client's perspective, he will feel that this is procedurally somewhat unfair in terms of how this appeal is developed.
Well, I get the need for you to have an opportunity to answer it, but if it were a good point, and I have no view on that at the moment, then it's kinder to tell you now than after a long trial. And also a great deal less costly. I mean, if there is no case, I understand all your points on procedure, Mr. Chastey, but if this case is in fact hopeless because of a point that nobody ever spotted before, then we would be doing everybody a disservice if we didn't say so at the very least.
Well, I don't know what my Lord means by say so at the very least. If my Lord said it,
well, we may find in your
basis.
favour and say that there's no grounds for amending the grounds of appeal. The grounds of appeal are not good enough to raise this point, but actually looking at it, the court can't see how this came to succeed, but there we are.
But if my Lord did that, if my Lord was minded to do that, I would ask my Lord not to go any further than that, and the parties would then need to make their own decisions, if I may say, armed with that position.
Yeah, well, we'll have to think about it, but even if we're thinking of saying something of that kind, it's a good idea for you to regroup tonight and have a think about what your answer is. It's not a complicated point.
Well, my Lord, that's something that we will do.
It's we all looked, well, I looked at this pleading thinking it was a very unusual, what I'm afraid I still call Section 459 petition. A very unusual set of allegations to make. And for my part, when I looked at it, I couldn't see why. I think my Lord was fairly long way ahead of me. But I couldn't see why it was pleaded in this rather unusual way, with this emphasis being placed on the information right, but now I do see. So it can't have been a surprise to your side to be on the information right is questionable, because actually the judge dealt with that and said he did think, he said, I can't remember precisely how he put it, but he said he did think it was pleadable effectively. It was, it was got past that stage. I think what I've tried to put my finger on, and my lord, I think, has been putting his finger on very effectively during the course of the day, is the question I've asked you, which is, how does this really add up to the row of beans? And if it doesn't, then it's a pretty simple point to say so. And of course, we can have endless litigation, and you can go back and have another hearing in front of Judge Eyre, and then you can come back here. But that's all a bit pointless if really that's the position.
I should have also said, my lord, that paragraphs 46 and 47 and the prayers at 7 and 8 for breach of the information obligation are not the subject of this appeal.
So paragraphs 46
and 47 of the petition.
So it survives anyway, you say. I thought it was
46, 47 and relief at 7 and 8 are not pursued in the appeal.
Right, what's that about? I'm sorry, I've just got to get it
Well,
out.
46 is saying, in breach of the SHA, the company's acted in breach of the information obligations as set out in 27.4, 37.4, etc., and is liable in damages. Further, in breach of 6.1, each shareholder directors have acted in breach of the information obligation.
Yes.
And are liable in damages. That's not the subject of any strikeout application. It was the subject of the strikeout application in the sense of, I think it was just mopped up with everything else below. But then that was based on, I think, the derivative. But it was never quite clear about that. But 46, 47 will go forward to trial.
Where is the application before the judge?
The application, my lord, I'm not sure the application is in the bundle, actually. Do you think it is?
We saw the statement, didn't
I
we?
think it's tab 1 of the supplementary.
Oh, my lords, but
Well, it says, the order that the judge made says, upon the respondent's application made by notice for an order striking out the petition in whole or in part.
yes, that's what I'm saying, my lord, is there was an application before His Honour Judge Eyre to strike out the whole, but the notice of appeal, of course, the appeal itself before my lords, is only to strike out certain paragraphs, and 46 and 7 and the prayers at 7 and 8 are not included. If my lord...
Well, they never were, because the draft order that's attached to the application notice seeks to strike out the whole thing. That was presumably the derivative argument. Then alternatively,
Yes.
it's 27, 37, 44, and the relief at 1, 3 and 8. 1, 3 to 8, sorry. So that wouldn't have caught 46 and 47 in any event.
So there is no denial and no attempt to strike out our allegations that there were information obligations and that they've acted in breach of them. So we're almost at a causation stage, you might see, in respect of which we're put to proof on the defence. Lords, I'm not sure I can say very much. Probably heard me more than enough in terms of this question of what I'll call bad faith, but it seems to mean an awful lot more.
Well, I think you have to say something about the allegations, the sort of substance of the appeal, which is...
In terms of the directors and subjective state of mind?
Yes.
Well, my lord, I tried in a sense to do that. I probably hadn't did it as expressly as I ought to have done. In terms of the directors are sufficiently identified in our submission in each of the individual paragraphs when it says and refers to the directors. And we've given at paragraph 8 a list of the directors and the dates on which they were directors.
I mean, you haven't pleaded a single directors' meeting or directors' resolution?
No.
said who was the moving force behind the company?
No.
Or pleaded anything about the chief executive officer? Or?
No, we haven't, my Lord. No. What we are saying is this was a collective decision by the board. That is our allegation.
Where does it say that?
Well, it says it by referring to the directors doing various things. That is what is meant by that reference to the directors. It doesn't single out any director for exclusion. So whilst I fully accept, my Lord, that the pleading could be expressed differently, the question though is, of course, is it sufficient? And we say it is sufficient for them to know. And it identifies the directors as a collective group because the decisions were made on a collective basis. And if any one individual director who's the subject of the claim wishes to step out and say, I see that you have included me as part of the collective, but I didn't do anything, then he'd been able to do that. But the defence is on behalf of all of the defendants.
Are they all parties to all the directors are parties, are they?
There are 14 respondents who were directors at the material times. Some come in and go out and say they're not a director at other material times, but that's featured in paragraph 8. And as I say, my Lord, the defence...
None of them has ever been separately represented.
No. The defence is a defence for all of the respondents. None of them seek to distinguish themselves from the others. And they of course, know whether they should do that. So it would appear, if I can put it like this, that the defendants are prepared to stand or fall together. And that's inconsistent in our submission with any suggestion that they don't know what the case is that's being advanced against all of them. There's not been a Part 18 request. I take my friend Mr Ashworth's point that the burden isn't on him, but it might be thought that there is some justification in it being said that before you issue an application to strike it out, with all that entails, it would be appropriate if you have particular issues to raise a Part 18 as a precaution and a preliminary step before you engage in otherwise. But we say, in terms of the individuals, the allegations against the individuals are sufficient because it is a collective position. I think the judge below used the phrase ganging up. I'm not sure that's a particularly appropriate way to describe what essentially is the board of directors. They are taking a collective decision. That's what we say.
All of them acting in bad faith is your case.
Yes. But
I mean,
they know that, I'm sorry, Mel, they know that. They can't say they don't know that's my case. I might fail, but they know that that is my case.
I mean, perhaps on a matter of detail, but it won't be a matter of detail to them. How do you maintain a case against Rachel Horsefield and Zilla Ellen Bing Maddock, who were not appointed until October and November 2018?
I'll have to pass on that for the moment, if I may.
I appreciate it's only 2 out of 14 respondents, but they are named as respondents. And
of course.
I don't actually see on any basis. Oh, I don't at the moment understand.
I'd have to check the dates of various matters.
They all have reputations in business life, Mr Chasty, and making them defendants to an action in which allegations of clear fraud are made against them without them being singled out as having done anything wrong is pretty careless, isn't it?
Well, look, I think we've probably been lulled into a little bit of a false sense because, of course, neither of those two individuals have made any point at all along the lines of...
I think the point has been made by Mr Ashworth. Further down the line, there may need to be separate representation.
Yes.
But anyway, I've made the point.
You've made the point, my Lord, and all I can respond by saying is I can check that to see the relevance of the 31st of October, but I would also make the point, I'm not sure this is in my defence, but at least I make the observation, that there's not been any application by either of those two individuals on that ground that the Lord has in mind.
Can you help me with this, Mr Chasty? I mean, at the moment, we have an allegation of bad faith fraud against a number of individuals, And it appears that the real nub of what is said against them is that there was an implied obligation to give information as to 13 transactions. It appears no complaint was made between transaction 1 and transaction 2, or transaction 2 and transaction 3, but as to 13 transactions, and that those directors, considering those transactions, acted fraudulently, bad faith, in not giving you information about them in a commercial situation where the company needed to raise the money to make acquisitions or make investments, and no doubt people were falling over themselves to invest in the company. It's a pretty bare allegation of fraud that they didn't think to tell you about it or ask you, particularly when you were no doubt notified of all the resolutions that needed to be passed to issue more shares, and didn't go to them and say, hang on, you've just issued the first tranche and you didn't ask me, and then you say in relation to the second tranche that they're acting fraudulently again. I mean, to me, I find that, this is business and commercial life. Life's a bit tough. You have to protect your own interests in business life. It's not as if your client did not have a very clear idea that he was not flavour of the month, because he was engaged, had spent several weeks in court in front of Mr Justice Blair accusing them of fraud. Not them, but not the people in this case, but some people. So there was no love lost. I mean, how does that add up to fraud in any real sense?
Well, we say the essential elements are there. We have these unilateral decisions that we say they knew of our entitlement.
Well, when you're subjected to a fraud and somebody tells you about it, that it's happened, don't you have to go back and say, hang on a sec, don't do that again? And then the second time, don't you have to go back and say, well, you've done it now twice. This is all very unfair.
But when we about these various things,
surely you must have been told about the issue of shares when you were a shareholder.
Well, no.
No?
No. Now, I'm looking at the pleading, my lord, and looking at the way in which this has been put. It is being said in the defence, I'm sure, that we were made aware of various things, but there are... this isn't a case of we don't know about 2 and 3, but we then find out about 4. Our case is in respect to all of those transactions. This starts at paragraph 40, and it then at 41 has the table, and then 43 has the reduction in the shareholdings. I think it's right to say that the defence will challenge our knowledge and what information we had, but that is the case that we put forward. That is
well, I just don't understand how, on the basis of company law, a resolution can be passed by the members to change the share, which it must be. Directors can't change the shareholdings and shares in issue in a company without passing a resolution. My lord will correct me if I'm wrong.
My lord.
So you must have been asked to, and it's not alleged here that it was concealed from you.
Well, we say that the transactions were concealed and the failure of the information. We were not provided with this information.
Which paragraph?
I think I suppose 44.1.
Yeah.
You say. I mean, some of these issues may have been authorised by the directors because there were sufficient unissued shares and an existing authority for the board to issue the shares, in which case you would say under the information obligation you should have been notified of the proposed business of the meeting and given the board papers. I understand that. If there had to be a shareholders meeting to increase the capital and so maybe to provide authorisation or whatever, then you should have been given notice. And there's a hint actually really in 44.3 that on some occasions you were given notice, but you say you were given inadequate information. So you actually say that I mean, this suggests that at least in some cases the Zedra did apparently give its consent to the share issue, but
based on insufficient.
But on insufficient information. I mean, it's quite not sure what is being said there. It's hard to see that you didn't know that some issues were being, some shares were being issued.
Well, the Lord will want to pick up the defence rather than, if I may say, those general matters of what might be thought to be surprise or a degree of speculation. But the way in which it's put in the defence is page 135 onwards, I think, on this. Paragraph 40 is admitted. 41, they take issue with the diminution or the shares diminishing in that way. 42, the accounts are dealt with. 43 is denied. 44 denies bad faith, denies the information allegations. Paragraph 3 admits didn't offer the opportunity to participate, denies they were required to do so. Then it's really at 44, at page 138, 4A, at all material times any resolutions have been circulated. So they're raising factual issues, and there's a joinder on those factual issues, which will be for trial.
Well, what's your reply to
The reply, I think, is in the supplemental bundle. The reply.
So we need to find the reply to paragraph 60, sub 4, sub A.
The reply. The reply at page 47 of the supplemental bundle at 30 asserts the obligation. The company didn't notify Zedra.
I'm sorry, I didn't get the page.
Sorry, 47 of the supplemental
Yes,
bundle.
thank you. Sorry.
Zedra did not receive sufficient information in respect of the shares. Being thus ignorant of the share issues, Zedra had no ability to object to them. Zedra didn't acquiesce in the share issues, nor would it be deemed to have done so. So there are joinders of factual issues and disputes about whether we did step back. So I think this started from the Lord's observation that, well, there were these 13 transactions, you must have known about them at some stage. But the pleadings address those points. And the pleadings make it clear that there are battlegrounds or battle lines being drawn in respect of those issues, which ultimately the defendant may be proved right, or we might be proved right. But if I may say, the general point that one might say about this is strikeout would be no different from summary judgment. A court wouldn't, for example, in a summary judgment application, strike out a find in favour of a defendant just because it thought that the case might not succeed.
I think the relevant pleading is at paragraph 31 of the reply. That's rather mercurial. It says such engagement with the company has included corresponding with the company in relation to share buybacks. Zedra did not receive, whether by email or otherwise, sufficient information in respect of the share issues in accordance with clause 4.2, including resolutions relating thereto. Being thus ignorant of the share issues, Zedra had no ability to object to them. And then there was a request for particulars, page 54 in the bundle. And where they ask you, please, sorry, you ask them, please clarify whether it's the respondent's case that Zedra was informed by company of each relevant allotment. I don't think that's been answered. Maybe it has.
Yeah, it's on page 63.
The answers start, my lord, a little later.
The answer to this one is on page 63.
Yeah. Zedra was informed of each relevant allotment in relation which it was entitled.
Yeah, but that's for resolution at trial, we would say. We all at least know what the issues are. And I'm sorry, Lord, to keep repeating the point. This is not a summary judgment application. This is a strikeout application.
Well, I mean, the answer is Zedra was informed of each relevant allotment in relation to which it was entitled to notice by reason of resolution, by means of resolutions circulated to the shareholders. The relevant resolution in Appendix 1.
Well, that's their answer to our question. It doesn't follow that we accept that answer. And we haven't gone into these issues yet. We haven't needed to. We haven't put our...
I'm sorry, that's your...
That's their answer to our question. We asked them for clarification of what they were saying, and that's what they gave to us. But it doesn't mean that we accept it. It's just at least we know what it is they're saying. So in terms of everybody knowing where they stand, at least in the issues and the allegations, we say that that at least is tolerably clear. They've not sought to strike me out on the basis of saying, there's our answer to this, and we can prove that, and you can't disprove it. That's not what we're fighting about. My Lord, I'm not sure there's very much more I can say about this.
Right, but do you want to take time? If you do, I think we might rise for a couple of minutes just to procedurally to see where we go. Do you want to take time, or do you want to conclude your submissions there and we'll hear Mr.
What could I, as it were, take time to,
Well, let us
decide whether to take
let's take 5 minutes.
And have you, I mean, there's been a lot of focus on ground 4, but I'm just anxious to know whether you've said what you want to say on the other ground.
I think we've said what we want to say, certainly on grounds 1, 2 and 3.
May not be very much to say on the reflective loss ground.
There's not really anything to say on reflective loss. This is loss claim at all. I'm not sure there's very much else to say on anything else in that case. So it is all about this. Yeah. So could I, while my lords, just take the opportunity to check how we wish to play?
Yeah, we'll resume it 10 to 4.
All right. The live streaming will continue. Sorry?
It's continuing, is it?
Yes, because they've only risen for 5 minutes. There is, but I'm not sure if it's working. But you can have a look. There should be a water fan just around. You'll see it. Is it not there?
Not working.
Oh, it's not working. I knew there was one there, but I didn't think it was working. I think this case will conclude today.
Possibly, yeah.
Yeah, because he's done, and I think if he's got a little bit to say,
Hmm.
should be done by 4:30, 4:15, 4:30.
Yeah.
Well, the schedule for 1.5 days is scheduled for tomorrow as well.
Yeah, that's right, yeah.
That's right. No, that's fine. Yeah, yeah. I'll have to drink it back. No, no,
I don't know what they're telling me they're going.
Well, I think they're saying if you want to go over and have a think overnight,
Yeah, but I
right?
don't want to do that if they're telling me that they're striking out. And I don't think they're telling me that.
I think he might be striking it, he might not, and he's.
He doesn't.
I don't seem that keen to me to finish it. I thought they might have wanted to. Are they not?
No, I'll get them if you're ready.
Okay, so you ready, Paul?
Council, we're ready?
Yeah, yeah, yeah.
Court rise.
Yes, Mr. Chase.
My Lord, the only final point is, as I understand it, my Lord is saying whether we wish to have the opportunity to reflect, to see what further points we might. I'm not trying to obviously negotiate or ask for any kind of indication. I'm in a slightly difficult position in the sense that if I am at risk, or indeed if I am going to be struck out, unless I take that opportunity and use it successfully.
I've no idea, Mr. Chastain. I'm not going to give you any indication.
In which case, my Lord, then I think, in fairness to my client, I probably should take that opportunity if it's being afforded
Yes,
to me.
I think I think you should take the opportunity. I think to give satisfactory answers to the court's questions is a useful exercise as an advocate. We've allowed 1.5 days for this case, so none of us has anything that we must do in the morning apart from this case. And I would therefore, yes, certainly be happy if you did that. And we discussed it outside, and if you come up with any other points that you would like to make to us tomorrow, we will give you the time to do that. So don't feel rushed.
Great.
I think that's the appropriate way to proceed, and also you'll have the opportunity to consider the application that Mr. Ashworth has made, and you may have some other points to make on the merits of that application as well. I mean, obviously this case has, taken an odd course, but I think you can see, Mr. Chasty, that if this court, which is not completely inexperienced in matters of this kind, came to the conclusion that the case wasn't a very good one, and said so, that is better than just saying, well, point 1 is good, point 2 is bad, point 3 is good, point 4 is bad, and we're not going to tell you what we really think, because even if you are right, that it's not a matter precisely for determination. So we would like to hear what you have to say on reflection, and if you come back and say, no, I can't tell you because I need to find this out and find that out, well, that's up to you to say, and we will consider whether that's a reasonable submission to make. I mean, I'm not trying to, if I can put it this way, hassle you or put you or your client under any inappropriate pressure at all. I want you to have a full opportunity to make submissions to the court to the best of your ability. So we'll, unless Mr. Ashworth has anything to say about that.
I don't mind.
Yes, my Lord would like to raise a couple of points for your consideration overnight.
Just in a sense footnotes, but really arising out of what we have been told today. Just on your prayer for relief, paragraphs 2 and 3 ask for the articles to be amended to reinstate co-sale rights and so on. But in the light of what Mr. Ashworth told us, that the co-sale rights have gone as far as, have gone completely, I'm not quite sure. Is that relief that's still pursued? You don't need to answer now, but it does seem to be...
I'd rather not answer now.
No.
But this goes back to the points again, that we rather expected that the existence of the flotation and the fact that that's happened would have been a reason why they might not have pursued the appeal, but if necessary.
Yeah, I mean, you do, I mean, I imagine you know how the articles have been altered,
Lord,
so...
We were fighting the appeal on the basis of the appeal, but not...
No, but this is a new development, as I understand it, since the hearing below.
Yes.
So all I
understand.
Anyway, that's that. And the only other point was sort of equally that I had been a little uncertain what paragraph 6 meant when it referred to removing the dilution since February 2016 and restoring the shareholding in percentage terms to the level of its shareholding as at 18th February 2016. Is that, or alternatively such a later date as the court orders, was that saying that there should be, in one way or another, Zedra should become the holder of shares equivalent to whatever it is?
Yes, that's what it was.
13% of The share capital as it is now?
Well, no, as it was then at the time of the petition.
Right.
Again, I need to reflect.
I mean, just... okay.
But
All right.
my lord will take. I hope my lord will understand why we've not sought to engage in those issues, because those are not part of the appeal itself.
I understand
they are just
that entirely. I understand
a situation
that
that
entirely.
currently exists.
I understand. It's just that them having been raised,
Yeah.
I think that it's relevant for us to know at any rate where you stand on it.
My lord, I wonder whether, given that this is an application that I am making, I haven't really made the application, I've just put the new ground in, as it were, without explaining it. Well, we say we don't need it because this is a bit like a logic puzzle, my lord. The facts in 44 do not, of themselves, without bad faith, give rise to any claim of unfair prejudice. But once you bolt on the bad faith, you might just get to a claim of unfair prejudice. We say, that's why we say you strike out the bad faith and the rest must follow. The rest goes. The unfair prejudice allegation no longer exists. So that is why I say, well, my learned friend says, it's all terribly unfair, it's all new. We say it's not new. This is exactly what we were saying below, what we were saying here in our skeleton. Once you take out the bad faith, there's nothing left of this allegation.
So you don't need to make your application.
I'm sorry, my lord.
So you don't need to make your application.
Well, I'm saying
it's
if-
all irrelevant
I'm
because
saying
it's
if you're
already there.
against me, my lord, on that.
Sorry?
I'm saying if you're against me on that, then I do make the application. I make the application on the basis that this is not a Das and Singh type situation, which is a case after trial, where there's been a whole trial and someone's trying to raise a point on appeal which requires new evidence, for example. This is a pure point of law. Does that pleading, as set out, give grounds for unfair prejudice on it?
Well, you will also have an opportunity tomorrow to respond to Mr Chasty's considered response, not only to your application, but to any other points that have been put to him by the court.
Settled.
Okay, we'll resume at 10:30 in the morning. Thank you.
All right.